Oh, that's
We're live, by the way. JR, of course, and not legal advice. We did a earlier episode, part one. The Supreme Court did not have the courtesy of reducing the amount of time of oral argument. So we went during the intermission, we watched the second part, and we are coming back to do the second part and kind of talk about what our conclusions are with regard to this hearing and maybe the implications it has elsewhere and
right.
whatever else. And the way we're going to do it this time is I'm going to let JR start the conversation and give me his pitch. Then we'll come
Okay.
back to me and then we'll go from there. But before, oh, you want to say something? Go for it.
No. Let me see if I can do this. I want to try to do this the right way. So I'm going to go to another tab. Okay. Can you hear and see me?
I can see you.
Can you hear me?
I can hear you. It's
Okay.
like the Who.
Let's see if you can hear this. You ready?
Yeah.
Let me know if you can hear it. Can you hear it?
No.
Oh, damn it. Didn't work. I had it stopped right at the part where he says, and oh, by the way, it's pronounced
Jarkessy.
Jarkessy.
Yes.
And he makes a comment about how, there's been multiple versions, but this is how it's said. So I thought, and I said this to you earlier, I really felt like he was speaking to us.
Yeah. So it was very funny because we always make fun of the fact that we can't pronounce it
We
correctly.
can't pronounce it correctly.
But during the oral arguments, it was probably pronounced 4 or 5 different ways. So
Yeah.
we feel vindicated. And before I let JR take it over, my friend asked me to help him round up his 37 sheep. I said 40.
I missed it.
Rounding up.
Oh, got it. All right. Yeah.
All right.
Come on, one more.
One more. I'm working in a mirror. Working in a mirror factory is a job I can really see myself doing. And last but not least, a girl walks into a bar and asks the bartender for a double entendre. So he gave it to her. All right. Boom.
Okay.
So we're talking about, just to set it before JR starts off, we're talking about Jarkessy and the SEC and that action that was before the Supreme Court. We talked about the first half this morning. So JR, go for it.
So the second half then obviously was the defendant in the claim, Jarkessy. And the second half focused more on the facts of this case than clearly the first half did. Would you agree with that?
Yes.
And the real crux of the case was Jarkessy was charged, I'm imagining, was tried and convicted by an administrative law judge by the SEC under 10b-5. Now 10b-5 is, I don't want to say it's a catch-all, but it really is a catch-all for market manipulation and fraud. And fraud is a common law principle. Now, there's a variety of elements of fraud. Some need to be proven in different types of cases. But why that's important is because if it's determined to be a common law right, then the Constitution gives you the right to a jury trial under Article 7, under Article 7. And so that's where the emphasis on the second half was really, what is 10b-5, and if it is a common law, can the court rule such that their ruling is very narrow and only specific to this case, or if they rule more broadly, what are the implications of that? And we talked about some of those implications in the first half, but they really talked about them in the second half. And they made defense counsel go through a variety of, give us examples of a similar situation that wouldn't apply if we rule in your favor. And I felt like he stuttered a little bit, like he was like, well, I'm an expert on the SEC and how this applies. And she's like, yes, I understand that, but give me some examples of where, if we rule in your favor, why we can do it narrowly and it not impact other administrative agencies. So I thought that was a very poignant question. The conservative justices really didn't ask that many questions. Thomas, I think, threw him a softball. Gorch, is it Gorch? I butcher his name as well too.
Gorsuch.
Gorsuch, I definitely got the sense that he's ruling in against the government, just based on his questions. So my takeaway is, I think if the liberal justices, and I don't want to say all of them because there was really only one or two, if those two justices can get over the hurdle of this being a broader implication and find a way to rule against the government and keep that ruling very narrow, I think you'd see like a 6-2 or 6 to a 7-1, and then one maybe concurring or dissenting. But it definitely is, and we talked about this earlier. It wasn't the big government versus little government that you would expect to hear out of kind of the liberal side and the conservative side. It was very factual or constitutionally factual, in the sense that they were really diving deep into Article 7 and then this whole basic common law principle and the statute that was passed by Congress. So that's my take on the second half.
Okay. So my take is, one, the second half was no different than the first half in terms of the focus. 3 issues: non-delegation, appointments clause, and Seventh Amendment. There was nothing about the other 2 points. Or I think in the rebuttal, the very end, the counsel for the SEC, maybe 30 seconds on removal. That was it. But basically, I don't think anybody believed that this case is going to be decided on anything other than the Seventh Amendment and the right to a jury trial.
Jury trial.
Yep. Yeah. And to set the stage for that, so Jarkessy is a broker. He gets into trouble. They go after him. They get him to disgorge. So he got some amount of profit. I think it's like $635,000. He gets this profit. So part of the remedy that the SEC got against him was he had to return that $635. Now the court determined that based on precedent, disgorgement, getting rid of that ill-gotten gain, does not give you the right to a jury trial. It's not a claim that was recognized back in 1790 that would give you such a private right.
1791.
I know. I was approximating. I understood. I didn't want to be
rounded down.
I didn't want to be too perfect. I don't want to like embarrass you. So yeah, whatever I just said.
Disgorgement.
Disgorgement. So that was not a remedy, but the fine, they also gave him a fine of $300,000, and they expelled him. So the issue was whether the fine, fining somebody, gave you the right to a Seventh Amendment jury trial. And the way they did that, as JR said it, I'm just repeating it to say it in a different way because I think it's pretty confusing. And for us, I think it's confusing. And for other people, it might be also. And then when I looked it up, it was confusing. So there's something called the public rights doctrine, which means that if in fact it is for the public benefit through a statute that protects, through a governmental statute that protects the public, then that is something that's not entitled to a Seventh Amendment protection. And if it's something like fraud, and that's why JR was saying the 10b-5, because 10b-5 is basically a fraud claim. The difference is in a common law. And we say common law, so back in 1790, if somebody ripped you off, you could sue them for ripping you off for fraud. And there would be certain elements that you have to prove that they, for example, they lied to you, they intended to lie to you, they took something from you and you suffered harm, etc. And when you put that claim together, you'd have to prove up each of those elements to win. So now what's happened is at some point in time, the legislature passed the 10b-5 law, which is also a form of fraud, but it doesn't require exactly the same elements as a common law fraud claim. But the way the law is written, it doesn't have to be exact. It has to be basically same kind of purpose and intent. The laws, in other words. So the fraud law, the intention of the fraud law and the intention of the 10b-5 law, they kind of have to be similar and impact things similarly. And the argument was whether, notwithstanding the fact that a common law fraud claim requires more elements than a 10b-5 claim, were they kind of sufficiently similar to give you the right to a Seventh Amendment jury trial?
Right.
And obviously the counsel for Jarkessy, of course, they indicated that it did, and they distinguished that it didn't apply in all situations. For example, and JR was talking about it, Social Security benefits, OSHA. There were certain regulatory efforts that could be taken that impacted individuals that didn't trigger a Seventh Amendment right to a jury trial. And in this particular case, in Jarkessy, he was trying to indicate that since it was a common law fraud claim, this was the type of claim that should trigger a right to a jury trial. And if that is the case, we were thinking about it, and we talked about it, how could a court narrowly interpret that? Well, if they want to rule that you have a right to a jury trial, maybe it's in all 10b-5 cases. Maybe it's in all fraud cases. Maybe it's in all cases where there's intentional misconduct. But there might be a subset of cases that you can identify, and those cases will be treated differently. The liberal justices didn't seem to buy that in particular. But what I found, so that's my pitch. I thought, to me, it sounds like 7263. There'll be some limitation. Either they will limit it to fraud claims, or they'll limit it to all cases where there's fines imposed or fines and penalties. That's slightly broader, but I don't think beyond that, because I think they will limit its impact to the facts. Even though they discuss the facts of this very little, I think in the end they're going to limit it factually.
Well, that's the only way they can keep it a narrow decision. They're going to have to circle back to the specific facts and the specific 10b-5, because if they don't, they're going to broaden the scope of the ruling.
What I found like incredible, and I don't think it's either the intention or it wasn't. So the second half, most of the harder questioning was done by the liberal justices. That would have been Kagan, Sotomayor, some by Jackson, but less.
Yeah, and it was definitely Kagan and Sotomayor.
Yeah, and they were trying, basically to say that the law, and we were talking about Atlas Roofing, that case, they basically said that was, basically decided and why you're here. Basically, that was kind of the discussion. But they indicated, and so now they're just talking, and they're not talking about, so now they're referring to a matter where there's a private individual versus a private individual. So in this case, it's government, SEC, versus private. And because it's government, the court, including and especially the liberal justices, indicated that that wasn't a good set of facts. But if it was private versus private, that would be a much tougher question. That's what the liberal justices said. So in my read, the conservative justices, if that's going to be a tough case for the liberal justices, that's going to be an easy case for the conservative justices. And if you look at in what circumstances do you have a private versus private, all those SROs are private. So if in fact, I'm going to throw it out, Alpine. Let's just talk about Alpine, for example. So FINRA, private, has a enforcement proceeding against Alpine, private, and seeks monetary relief against Alpine, either a fine, some penalty, something like that. These liberal justices have just told me that they think that's a problem.
Yeah.
And that case is not before the court yet. But I thought when they're talking about that private court, and we know that FINRA says absolutely 100% they're private. They're not a state actor, despite the fact they get immunity, but they constantly make the reference they're not the government. And I thought the language by the justices is going to come back and either bite them or was intentional. And I thought maybe they were thinking ahead, and maybe they have a problem with the way those kind of semi-autonomous governmental agencies work. I don't know. One more thing. The other thing that I found was really, I almost took my breath away, and the attorneys weren't well versed. There was a discussion about a injured party. So this would be now a consumer who was defrauded and would be able to sue to get their broker for fraud. And they can't because there's an arbitration provision.
Right.
As a customer, you can't go in. And unfortunately, the attorney representing the Jarkessy maybe he doesn't follow ham as much as we do. But to me, it was obvious that was wrong. That was incorrect. That was a lacking. You don't have that as a remedy. And I think that makes a big difference. So to me, there were two very key things that were brought up by the liberal justices that I think expose FINRA in my mind.
I'm just kind of thinking about how, if you think about how the arbitration clause gets into the terms of service, in order for a member firm to become a member of FINRA, they're required to have that arbitration clause in their terms of service. I think that could play a huge role in it because it's not voluntary between the parties, because that's the general basis of an arbitration clause is well, you agreed to it. Well, the only broker dealers in the United States are ones that are FINRA members. So no, I didn't. The government forced. I mean, you can make the argument based on what we're hearing in this case. You can make the argument that no, they did exactly what they did here. They took my right away, which was the general premise of the whole conservative side of the bench. You've taken a right away that's been embedded in the foundation of our Constitution for 200 plus years. This right to have your peers review the evidence against you. And in the arbitration provision, I don't really have a choice.
Right. Yeah.
Yeah, you make a really good point. That's not one that I thought of when I was listening to the arguments.
Yeah, what occurred to me was exactly what you're saying about the arbitration. I don't know exactly, I haven't figured out exactly how it gets there, but we've been talking about this for months, that somehow I was waiting for something that might impact the arbitration provision. And here, again, because it was the liberal justices that were talking, I thought it was more powerful. And I think if the adjudicatory system of FINRA is held in any way to be unconstitutional, and I think there is a decent chance there, at least in part, that will be, that if in fact your requirement to arbitrate and forego a jury, because of course I would go in I would do exactly what Jarkessy is asking for here. I want the right to be able to go to federal court. In fact, that's what the attorney said. He doesn't even want to have it a requirement. He just wants the party to be able to choose. So if I'm the one who's been violated and damaged, because I have a damage claim for fraud, it is a common law claim. But what the attorney for Jarkessy said is, I should have the right to decide. If I want to go administratively, okay, I have that right. If I want to go to federal court, I should. It shouldn't be the other way around, where the party that is perhaps should be one making that decision. And that seemed to trouble a lot of the justices throughout in terms of the decision making, and I'll add one more point about how the government would be able to remove a protection. And they talked about it in this way. So if you start off with a fraud claim back in 1791 for JR's purposes, and just because they call it a 10b5 claim doesn't make it any less a common law fraud claim. That was kind of the argument. And I think, to be honest, I think that's a persuasive argument. And even though the ironic part is, even though, like I said, a common law claim would require, you have to prove damages, for example. And in the 10b5, you didn't have to prove damages. But the way they filed their complaint, the allegations of the complaint were a common law fraud claim, even though they characterize it as a 10b5 claim. So I think there will be the start. This is my conclusion, and then I'll let JR state his. I think this is the start of limiting at the SEC's power, and we're going to do it one leaf at a time. And I think inadvertently, it may be the start of supremely limiting SRO's authority, which I think should be limited. I think there's no way they should have the authority and power and immunity. And maybe that's what will happen. Maybe that, to the extent they're private, maybe there'll be a recognition. Maybe the limitation won't be so much that their authority be limited, but to the extent they act, their immunity may be limited. And maybe they'll be at risk. And maybe that will change their behavior.
Well, I think and you heard defense counsel say this, the SEC, and he said it flat out, he's like, the SEC knows this is coming because they've already started to move more of their cases into federal court. And the one thing I was surprised going back to the first half was there's only 3 administrative law judges at the SEC, and he said there used to be 5, so now they're down to 3. But let's think about that for a second, because that tells me one of two things. It tells me, all right, maybe they are making the shift to federal court, or maybe they're not enforcing these laws the way they should and taking appropriate action the way they should. And would they be doing that? Maybe they would have more administrative law judges. I mean, part of the reason these agencies have kind of this, judge, jury, and executioner system is because, number one, they have more of an expertise than a federal court judge does in that particular area. The other reason is it's an expedited procedure. Now, when I say expedited, I don't mean it's, well, here's your ticket, we're going into court, you're done, it's over. I don't mean it's expedited in a day. I mean, going into federal court is lengthy. There could be 150 cases in front of you. So it could be several weeks till several months till it gets to that point where you're in front of the judge or you're in front of the jury. Then it can be several weeks till it's done. Then you've got all these different appeals, and it could be 3, 4, 5 years before a case like Jarkessy makes its way through the federal court and there's some type of definitive finality to the case. Whereas if it's an administrative law procedure, that can all be done in 6, 8, 10 months, or even a year. So I guess my point is if they're already shifting to federal court, then okay, no big deal. But if the reason they've only got 3 administrative law judges is because they're not doing what they're supposed to be doing, which we've said all along, that's the bigger problem, I think.
Yeah. So I'm going
to because the final thought is if they're reducing their administrative law judges because they're not doing what they're supposed to be doing, and now they've got to go into federal court and know that it's going to take upwards of 2 to 3 to 5 years to have finality to a case, they're really not going to be doing what they're supposed to be doing then.
Yeah, if they create the urgency by just reducing the staff, that's really not a good position. Right. Yeah, right. I was going to take it to more. So, I think it's going to be, the implications are potentially huge, but I'm going to look at Alpine because that's, we're always interested in the practical side. Because there's an Alpine case involving FINRA, and go ahead. You were going to say something.
I was just going to say it's going to be interesting to listen to those oral arguments to see if anything in this case is brought up, or if if they focus some of the emphasis of that case where this case was focused.
Yeah. So, there was no discussion about, because what I was thinking about is, so how do you do it? So I told you that I think that, FINRA has got issues, but I also think that the court was pretty clear that if you're not dealing with the monetary issues or property rights, then there wasn't much to argue about. So, like, if they were trying to discipline, didn't seem like there was any prohibition against them disciplining their own or anything like that. It was really the monetary issue and the property right. But they talked about property rights a little bit, but they didn't get very specific. So the monetary issue is really easy. So if we go after, I'm saying me, FINRA, I'm FINRA now, I'm going after Alpine, I just drop the issue of the money, sever it. So now I'm going after expulsion or some penalty. I believe I probably could do the penalty, no problem, because I'm not permanently impacting the property right.
Right.
But if I expel them, I'm impacting their right to be a broker. So the issue then would be, and I'm sure that would be litigated, because there would be a question, is that a property right that deserves the protection of having a right to a jury trial? Because it's a common law right that goes back to 1791 when JR was just a little boy. And so I think in the grand scheme of things, if for Alpine, listening to that hearing tonight, that was the death knell of Alpine. For the mechanics of it, we'll have to see how smart, because to my belief, FINRA has been ridiculous in terms of how they've handled the Alpine matter from start to finish. It's a joke. Will they continue? I don't know. I'm sure that these cases do impact their decision making, but in the end, nothing that happened today should give Alpine any pause that things are going to be okay, because to me it did not. As to the monetary issues, I think they have an argument they can make, and it's now in FINRA's court and the SEC's court they can obviously, and I say it, how many times have I said this? Tomorrow, file it in federal court, put these suckers out of business.
Well,
we're done.
I think at the end of the day, given reading the briefs and reading all the allegations and the findings of facts in these cases, they're dead. They're dead here. We know that. And they're going to be dead in federal court if FINRA decides to take it in federal court, because the evidence is insurmountable. So, all of this was buying time. And I wonder if Jarkessy, take out Jarkessy, I wonder if they're even making these arguments to survive. I mean, we were, when we first looked at this Alpine case back in July, we were like, they're dead in the water. And it was because they were throwing the constitutional sink at FINRA. And that was when the case was still back in Tampa. Then it gets moved to the district court. Then all these things happen. And then lo and behold, Jarkessy pops up, and boy, doesn't it all look the same. So it makes you wonder, if you pull Jarkessy out of the equation, if they would even be where they're at. But like you and I talked, they go into federal court, so they get a right to a jury trial. But boy, they're going to have a hell of a time dispelling the evidence against them.
Yeah. This is a matter of FINRA and the SEC again doing the right thing and not doing what they're doing is to protect their own power. That's all they're doing. And just so we have a clear understanding, and I think we've kind of alluded to this. So the courts look for good plaintiffs, because they don't want to decide a case and it's some scumbag who's the recipient of the benefit. So
I'm trying to pick one out. I'm trying to remember. I know there's one out there.
Yeah, I know. So there's two cases in the same DC circuit on appeal besides the Alpine case. Kim and I forgot the other one's name, but Kim is the leading case in terms of time. And I think that those and usually they're enforcement cases, so they got into trouble, and FINRA's going after them, and they're trying to kick them out and fine them. So none of those guys, if they're guilty of what they're charged, are the greatest guys. So we're looking for the best of the bunch, and it looks like Alpine is the least of the bunch. So they may lose just for that sole reason, that the appellate judges, when they have a chance to examine the record fully, they may determine that Alpine aren't really good actors, and they don't really care about helping them out, because in this case, they could just rule very narrowly on the injunction and move on, and it would be perfect. In my opinion, they could sustain the denial of the injunction. That means agree with the denial, and they'd be perfectly fine. There'd be no way to challenge that. They'd lose. And that's what I'm kind of hoping that happens. But there's other cases where the injured broker scumbag is not as big a scumbag. So we'll see. But I think at some point in time, one of these cases is going to make it up to the Supreme Court. It may be the next term. This might be Jarkessy, might be the 2024 term, and then the FINRA case might be the 2020, the next year's term, 24, 25. Right. And I think there's a another agency case that was just argued that, in effect, similar issue in terms of the breadth of the power of the agency. So that's kind of where they are at. Anything else you wanted to say?
No, just that, nothing else other than we're living in interesting times. That was, I've listened to Supreme Court cases before, but not with this kind of level of enthusiasm. It's going to be interesting to see how it plays out. I'm now even more interested in finding out how we need to listen to the Alpine case, because, like I said, if I'm the attorneys for either one of those, FINRA or Alpine, I was listening today, and I'm downloading those transcripts, and I'm honing in on where I think I need to put the emphasis of my argument.
Yeah, and yes, I agree with you. I agree, and I'm sure not just them, the other 39 friends of the court briefs that were filed.
Right. Right.
Yeah, but it was very interesting. I thought it was, most times in my experience, when I'm before a tribunal that doesn't have a great grasp of my case, so it's kind of new to them. So to distinguish, if I file a case tomorrow, I may have the same judge for the next 2 years, and by the time you get to trial, the judge kind of understands the case. But maybe if you're in front of somebody for the first time, they don't. And sometimes when you hear the questioning, I wonder the depth of their understanding. And they have a lot of cases, and they got other things to do. And JR mentioned a comment this morning I forgot to address, that because he was struck by Clarence Thomas asking questions. So I forgot the justice who died, who was friends with Ginsburg. So there were two justices that died a couple years ago.
Was it Brennan?
No. Starts with an A. Can't remember his name. But anyway.
Scalia.
Yeah, Scalia. That starts with an A, right? Scalia with an A.
No, yes. But his first name was Anton.
Okay, that's true. So he was like the head of the leader of the conservative side. And when he was the leader of the conservative side, in all the time that Thomas was on the court, he never asked a question.
Yeah.
When Scalia passed away, the next term, like the first one out of the box, it was Thomas asking a question. So either he was paying homage and tribute to Scalia and he would defer, or he thought that the court needed somebody new to ask questions, perhaps. But it's been interesting because he never did. And, like the first question this morning was Thomas asking a question. That's why JR reacted like that, because it was
just a little bit of history here. I mean, most people our age remember the Clarence Thomas hearings with Anita Hill, but I don't think a lot of people realize that Clarence Thomas was the second African American that was appointed to the court, and he was appointed upon the death of Thurgood Marshall. So, and those of you who are history buffs in the civil rights movement like I am, Thurgood Marshall walked with Dr. King. Thurgood Marshall argued many of the seminal cases in the civil rights movement. In fact, he argued Brown versus Board of Education.
Yeah, I don't remember the order if Bork came before Thomas. It may have been.
Yes.
Yeah.
Bork came before Thomas was 1992.
Yeah. So Bork. So Bork was at least in my understanding, Bork kind of changed the way the Supreme Court justices were chosen, because before Bork, I think they were
rubber stamped.
Well, not only rubber stamped, they looked to make sure you were qualified. As long as you were legally qualified, I think they would confirm you. With Bork, I think they did conclude he was a smart guy, but there were political reasons why they elected not to confirm him. And then after that, from that point forward, it's been a political issue.
Yes.
Yeah. It's unfortunate.
Yeah. Bork was a Reagan nominee. Clarence Thomas was Bush Senior nominee. But Bork was the one that really started the contentious nature of them getting nominated, and then Clarence Thomas basically took it over. But if you remember, it wasn't, I don't remember Bork. I remember hearing about Bork, but Clarence Thomas wasn't along party lines either. It was both parties, because Arlen Specter, who was a staunch Republican and a senator of Pennsylvania, was head of the Judiciary Committee at the time, and he was not too thrilled with Clarence Thomas when all the other stuff came out.
That was a K or an N? Not. Yeah, it was a. Yeah, imagine how that would be today.
Oh, it would be brutal.
It would be on Twitter, X, whatever you call, 24 hours a day. It was a to those that don't recall or weren't alive. It was kind of a accusation of some inappropriate conduct between Thomas and Anita Hill.
He was making sexual innuendos at her, and the claim was sexual harassment. And the reason I say it was sexual harassment is, for anybody that wants a good laugh, I'm not going to repeat what was said, but go back and Google hot mic during the 1992 Clarence Thomas hearings.
Yeah, hot mic. Yeah. So, but unfortunately, that was kind of like, whether it was justified or not for him, it did change the way the court what kind of handled. And somebody pointed out today, it's also interesting, and I don't know how it's going to play in. So now the court has recently, the court being the Supreme Court, has set their own ethical standards internal, because they never had any.
Right.
They just kind of abided by the principle that everybody would act nice.
It was a code of honor.
Yeah. And there have been some accusations of, conflicts of interest, whatever. So they've recently passed a set of ethical rules attempting to deal with those potential conflicts of interest, et cetera, taking money for causes, et cetera, all the stuff that we would rather they not be doing, and being objective. And so with that in mind, I think they fought it, not a big shock why they would fight it, to the extent that they had, perfect freedom before that. But now, because they have to comply, are they going to take a different view on regulatory bodies being kind of unethical? Or are they now going to say, it's good for the goose, good for the gander, now you have to comply like we do? We don't want to. But I wonder, somebody brought that up to me today. I had a conversation with somebody else who's filed an arbitration in the MMTLP matter. And one of the things we discussed was that, whether the Supreme Court would have to kind of change their tune. And just as a side issue, so there is at least one other person who filed a arbitration in the MMTLP matter for E-Trade, I believe. And it's an ongoing proceeding. And we are in contact. The three of us are in contact and working with an understanding amongst us as to what's going on. And it's nice to know that somebody else is involved, and I'm sure it will be very productive in producing, as good a result
Right.
as we can and getting as much. Same interest in getting documents, same difficulties that I face in discovery. So, that's just a side thing related to MMTLP. Anything else you want to add, JR? Any
No,
questions or things that
I think
caught your
that's good.
attention?
We've not gotten any questions. A lot of comments that your jokes suck.
Yeah,
People, I saw a
that's
couple
obvious.
comments out there about how awesome I am.
Yeah, that's
I'm
not
just kidding.
obvious. Yeah. Yeah. To the extent my jokes suck, that's, I can't change reality. It is what it
Yeah,
is.
yeah.
Sometimes they don't suck, but, like I said, it's volume. It's a volume business. And ultimately, and I see this, by the way, I infect. That's what happens. That's what happens. And that's my goal.
Okay, that's enough
All right.
for a Wednesday night.
All right. Anything else you want to mention?
No, I'm good.
All right. So, so we thought it was a really interesting day. Decision before June. We're also going to follow Alpine and the appellate works there, and we'll keep you apprised. And obviously, we'll keep you apprised as we go on. Hope that provide you some clarity. If not, I apologize. And like I said this morning, if you have questions that we have either screwed up or confused you on, just put it in the comment. And to the extent I can answer or JR can answer, we will answer.
Yep.
To all you out there, thanks for joining us. Have a great evening. Be well. Take care of yourself. And again, thanks again.